Minors, people under 18 years of age, sometimes referred to as children, but in some instances, you know, when somebody's getting close to 18, it doesn't seem like they're a child. Well, parents look after their well-being, and sometimes parents enter into contracts on behalf of the minor. But what happens if something goes wrong with that, and what enforcement can be had against the minor? Well, that brings us to this week's case. It involves this 9-year-old girl in Tennessee. She was involved in an unfortunately bad accident. The parents went out, they hired a lawyer. The lawyer proceeded to get a good result. And then he, the lawyer, brought claim under the retainer agreement, the agreement between the parents to provide representation for the fee that he was entitled to under the agreement. Went to court because in this instance, the agreement had to be approved by a judge. The judge looked at the agreement and said, wait a second, this is an agreement between the parents and the lawyer. The 9-year-old girl, the minor, did not sign this agreement, but importantly, she never could because she's under 18. Therefore, the agreement is unenforceable. And the amount that would be paid to the attorney, the judge determined at his own bequest, will be determined by what's reasonable. And in this instance, the fee that was being claimed by the attorney was $141,000. The judge reduced it to $131,000, or reduced it by $10,000, and said in his opinion, the opinion of the judge, that was an unreasonable amount. This was appealed all the way up to the Tennessee Supreme Court, and there the court agreed with the judge at the trial court level. So what's the point of this? The point of this is very simple. Many times, minors will need to have contracts entered on their behalf. The point is that the minor cannot enter a contract. If they're under 18 years of age, there's no state in the union that will recognize a contract made on behalf of a minor as to being enforced against the minor. So what happens in these situations? Well, what happens in these situations is that generally, the contracts remain completely unenforceable. When does that kind of thing happen? Well, it can happen in a number of ways. Most commonly, it happens in entertainment contracts. When you've got a child, and I say a child, and I use that term generically because a lot of people say when kids get to be 16, 17, as I said earlier, they aren't considered as children, but somebody under 18 is not considered to be an adult. And if that person under 18 enters an agreement with a music production company, with a band, or whomever else, and signs it him or herself, well, that is going to be unenforceable. What happens if a band, as an example, enters a contract with a record production company, and they then find that one of their people, one of the players in the band, is under 18 years of age, and that guy or gal says, hey, I'm out of here. I'm not going to go on and do what you guys have promised to do. Is that going to be enforceable? Well, that depends on what the relationship is through contract between the minor and the band. But generally, just generally, those agreements are unenforceable. So that's the lesson we learn in this week's case. A pretty straightforward lesson, and that is minors, people under 18 years of age, cannot enter contracts, and people dealing with them don't want them to enter contracts because they are unenforceable. We bring you these videos every week so you understand how the law works, so you can make the law work for you. I'm David Allen.